The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
21-year-old Laken Snelling seemed to be living her best life. The Tennessee native was going to school at the University of Kentucky. She was a member of the cheerleading stunt squad, and like many other young adults, she was also active on social media, sharing her life. But investigators say there was something she wasn't sharing, a dark secret hidden in her closet, a dead baby. Now Laken is under arrest, and we have the latest. But first, in July of 2014, Florida State law professor Dan Markell was murdered in his Tallahassee driveway, shot execution style in the middle of a bitter custody battle following his divorce from Wendy Adelson. Prosecutors say that Wendy's mother, Donna Adelson, the matriarch of a powerful South Florida family, became the architect of a deadly conspiracy. Emails and recordings revealed Donna's obsession with relocating Wendy and her two young sons to Miami. The only obstacle in the way was Dan Markell. She allegedly enlisted her son, Charlie Adelson, who recruited intermediary and lover Catherine McBanoa to hire hitmen. Now, over a decade later, Donna Adelson, at age 75, is on trial, facing charges of first-degree murder, conspiracy, and solicitation, accused of orchestrating a murder-for-hire plot born of custody and control. Wendy denies any involvement and has not been charged. And tonight, we have all the big moments from court, including Donna Adelson's big decision about whether or not to testify. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. And you know, I know, we all know that every suspect, every defendant has the right to remain silent. Such an important right, such an important part of our system of criminal justice. You don't have to say a word. You don't have to speak to police. You don't have to speak to prosecutors. You don't have to say anything when you're charged with a crime. You have that right, every suspect and every criminal defendant at trial. That's because the prosecutors are the ones who have the burden. Right? Everything is tilted that way. You don't have to do anything. And I'm not saying you're going to be charged with a crime, by the way, but I'm saying we, as Americans, we don't have to say anything. We don't have to put up a piece of evidence. We can completely just sit there because prosecutors are the ones who have the burden of proof. They have to prove the case. And not just sort of prove it beyond any and all reasonable doubt. I'm a former prosecutor. I know how high and how deep that burden is. Here's the thing, though, with this defendant, Donna. Her attorney said she was going to testify at a pretrial hearing. Wasn't in front of a jury, but at that moment, it seemed like, oh my goodness, he let something slip down. She is going to testify at the trial. So from the beginning, we presumed and thought that Donna Adelson would take the stand in her own defense, and today was the moment of truth. Today is when she had to stand up in front of that judge and tell the judge her intentions on whether or not she was going to testify. Take a look at how it all went down.
Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time, I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way.
The moment of truth. When every criminal defendant has to make the decision themselves, you can talk to your attorneys about it, but it's your decision, and that's why it's one-on-one with the judge in that moment inside the courtroom, and she backed down. Donna Adelson taking an opportunity to speak and not speaking. a little bit shocking, to me at least. Let's bring in Court TV anchor Julie Janae, live from outside the courthouse in Tallahassee tonight. I'm shocked. You know, I believed she was going to testify. I believe she always wanted to testify, that she would always testify. But before the moment we just showed, there was a little bit of back and forth before that happened.
Oh, yeah, a lot of back and forth today. Donna Adelson now joins the ranks of Sigfredo Garcia. He's the only other defendant in this case who didn't take the stand. We know Charlie testified, Katie testified twice, and Wendy Adelson, an unindicted co-conspirator, she has testified 3 times in trials over the death of Dan Markell. So only Sigfredo Garcia was the other one who didn't testify, and now Donna choosing not to testify inside of the Leon County Courthouse. Only difference is Garcia seemed to do it with ease. It was a quick decision in front of the court. Not so here. I mean, there was very high anticipation inside of this courtroom about whether she would testify, and it seemed to increase because there were several false starts. Now, the judge gave a deadline after giving everyone a long lunch. He said, when you come back, it's time to tell this court if you are going to testify. Here's what happened after that lunch break.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
Yeah, if I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or
Absolutely.
review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent.
public that has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court here allow Ms. Adelson to participate at sidebar as she is entitled, and for the court to for us to address additional issues that are weighing on Mrs. Adelson's decision.
His approach, we're not going to do this for very long.
So this was an unusual thing to happen in this trial, for a sidebar to happen so that they could be out of the range of the people in the gallery. Now, there were some issues in the gallery today. The judge had to reprimand and instruct the gallery to make sure they weren't chatting or making noise or making gestures there. There was some laughter at certain points in the trial, so later the judge, outside the presence of the jury, made sure they knew to keep it down. It's a packed house inside of that courtroom. But then finally, after all of these different false starts, we also heard Donna address the court. This is before she ultimately said that she would not be testifying.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify, but ultimately you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Now, Donna Adelson there, not afraid to push back on the judge. The judge telling her, you have to make a decision, and she's still there at that point refusing to. I think, Vinnie, that's one of the reasons we expected her to take the stand and tell her side, because in pretrial hearings, the time that she was in her first appearance, it was almost like she couldn't help but speak out, even when she wasn't supposed to.
Oh, absolutely. And I think she's lived a life where she's pretty much tried to manage and control every situation, whether it's her life or Harvey or her children or whatever, and grandchildren as well. Okay, so what happened after all that, Julie?
More confusion, really, because once we learned that the defendant was not going to testify, it seemed like the defense didn't know exactly what they wanted to do next. The judge asked them if they had any more witnesses. They were not sure. They then said they wanted to, after some deliberation and more time taking some sidebars with each other, they then wanted to put in different items from Donna Adelson's planner. Now, let's first highlight what the state has already put into evidence and wants this jury to see in terms of her planner. They've got this one from July of 2014. That would be the month that Dan Markell was killed. And it has here the make and model and license plate number of Dan Markell's car. The prosecution wants to make sure that that is seen so the jury can make the connection that she wanted to pass that information to relevant people, i.e. the hitman in this case. There's also another section of this planner from 2023. This is the same month that Charlie Adelson was convicted and Donna would eventually be arrested. But before that, there is an entry where she is trying to sell some big items, and the prosecution wanting to show that this means that she was making plans to flee the country and not come back. But what the defense wants is to bring in the entire planner for that year, for all of 2014 and all of 2023, to show that she had other events, other things that she regularly did, and other times that she wanted to sell those same items. They said that was for the rule of completeness. And ultimately, finally, the jury came back in, and this is what they heard.
All right, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
And with that, this trial that was slated to go 3 weeks is about to make the mark. Closing arguments beginning in the morning after those jury instructions, and this jury is going to be weighing first-degree murder, second-degree murder, manslaughter, or not guilty.
All right, Julie Janae, stick around. We've got more questions for you, but let's bring in our think tank. Live in studio tonight, criminal defense attorney, former assistant state attorney, Miami-Dade County, and former assistant DA in Atlanta, Daryl Cohen. Criminal defense attorney, law professor Meg Strickler, and criminal defense attorney, the man behind the glasses, Josh Schiffer. What happened?
I'm perplexed. This apparently is not the same case that I've been following for years. Donna apparently did not have the opportunity to speak with her lawyers to make a decision as to whether she should or should not testify. The truth is, the moment of truth was she was truthful by not testifying. That's her only chance.
I was surprised. I thought she would testify. And the fact that she gets up there and says she needs more time and the lawyers need more time, I understand conceptually. It's such a big decision. But we've had enough time.
We know how a trial goes.
That judge was not putting up with any of that.
I love Judge, by the way. I'm a big fan of Judge. I want to see him on his happiest day as well, because I think it's probably pretty similar to his demeanor in court. I just love it because he's so matter-of-fact and clear. And you're right, Donna had all the time anybody else would have to make this decision, and her pushing back like that, that reflects on her bully attitude in life generally.
That's not going to help her at sentencing, by the way.
No.
If she's found guilty of anything, like a lesser included, that's not going to help her at sentencing.
No.
She pushes people around. She doesn't take answers as answers.
This affects the rest of my life. Yeah.
Seriously?
Like
Surprise.
every other criminal defendant in every murder trial ever. We know this moment's coming up. You know she's watched Charlie's trial. She probably watched Catherine's trials. She probably watched Sigfredo's trial. Like, my goodness, you know this is going to happen. This doesn't just like, oh, we've got to decide? I don't know. What are the specials? Can we go over the specials again?
And like, at 5 o'clock dinner specials is what she's going to have for the rest of her life that's been affected as a result of the fact that Dan Markel's life was completely affected. He didn't have a rest of his life.
And I think she's one of those rare clients where every defense lawyer in America says, no. You, no testify. There is no you opening your mouth and getting exposed to a couple of great state prosecutors.
Do you think anyone could tell Donna what to do, though? Really? Do you really think a lawyer could tell Donna?
Oh, but you know that prosecutor was chomping at the bit to cross-examine.
Please
she was doing this. Bring him.
Do you think the conviction of her son after he testified impacted her decision?
No, not at all.
No, I think what impacted her decision is ultimately, Donna, if you testify, you're going down no matter what. You'll probably go down regardless, but you're going down no matter.
All right, the beeper's going off. I think we're out of time.
Let's go.
Either that or I need some glucose, folks. Anyway, Think Tank is staying with us. When we come back, the final witnesses for the defense, Julie Janae will join us again, plus coming up next hour. Tonight on Vinnie Politan Investigates, we continue our in-depth coverage of the case against Donna Adelson and show you the moment Charlie's girlfriend, Katie McBanoa, admits it all to investigators. But is it the truth? Tonight, we investigate.
The Court TV podcast will return.
This time I don't want to testify.
Very well.
Well, what time are you going to testify? Like, this is it. You either testify now or you don't testify. Like, she's not testifying. Donna Adelson declined to speak, but there's still a lot of things that happened in court today. And Court TV anchor Julie Janae is live outside the courthouse in Tallahassee, Florida. So the defense wanted to call someone from jail as a witness. What was that all about? Who are we talking about here?
Yeah, Vinny, this happened first thing in the morning, and it was a signal that there would be many more confusing things that happened today. But Attorney Josh Zellman, outside the presence of the jury, asked for the court's help in ordering a surprise witness who happens to be a corrections officer that they needed help talking to the defense. They wanted them ordered to be able to talk to the defense. Here's how that request went.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Now, you heard it mentioned in Jackie Fulford's explanation as to why it was taking so long to get Donna to decide whether to testify or not testify is because they needed to get her up to speed on the evidence, and they had this potential new witness and didn't know if they were going to testify. Now, the outcome there is that we had Under Sheriff Bryce Google who came into the courtroom. He's not this mystery witness, but he did speak to a captain who spoke to that individual, a deputy corrections officer, Franklin, and that person was saying, I got contacted by the defense. I want to know if I have to talk to them. They're coming here to meet me. And Under Sheriff Google said that he spoke to the counsel with the Attorney General's office, and they said without a subpoena, you don't have to. So that's how it ended. The defense didn't call that witness, didn't secure a subpoena because they said they didn't really know what this person would say. That's why they wanted the meeting. And here's the curious thing. We still don't know what information they thought that witness would have, or if they learned about them through a certain means. We really don't know, but this was mid-trial, and they rested without calling any more witnesses.
Strange, to say the least. Kind of bizarre, and still a mystery. Okay. There's something else that happened today. There was a witness in the courtroom who shouldn't have been there. Like it's very clear, right? If you're going to testify in a case, there's the rule of sequestration. If you're going to be a witness, you're not supposed to be in there until you testify and are released.
You know what's interesting, Vinny? The court is very strict on when people can come in and out, and there's a lot of deputies there to tell you where you need to go, and if you ask them, they will tell you where you can sit and if you can be in there. But this is something that really annoyed Judge Everett today, because it started yesterday when a witness who came in to talk about being a realtor for Dan Markell and trying to help the Adelsons find something here. He had been sitting in the courtroom all along, all day, didn't know he wasn't supposed to. It was a my bad by the defense. He still got to testify because it wasn't on purpose. But then today we had an expert on the stand. First of all, we had the divorce lawyer for Wendy Adelson who was on the stand, Kristen Adamson. She testified. And while she was testifying about the divorce, there was an expert, Linda Bailey, for the defense, who was sitting inside the courtroom. And here's what happened when the prosecution found out. Other people mentioned that this woman has been inside of the courtroom during that testimony. The judge had this to say.
With respect to the context and the statements, we were obviously asking that...
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration.
The judge had to take a moment, go back to the law books to research whether or not he should exclude this witness because she had listened to that other testimony. But he found that the law said if their opinion changed because of the testimony, then they should be excluded. She said that her opinion had not changed, so she was allowed to testify.
All right, so she's the expert in all of this, these areas of, you know, how these things normally go. What does she have to say?
She explained that this divorce that we have called contentious, this custody battle that we've called bitter, she said it wasn't that at all. It was basic. It was run-of-the-mill. That Wendy Adelson and Dan Markell were actually very amicable in their back and forth and the way that they were filing things, and that Wendy Adelson was a model client, that the way Donna Adelson was reacting to the divorce is typical of divorce and custody proceedings. Take a listen.
You're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
When you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it? So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question.
Probably the most fiery cross-examination that we've seen so far. Here's something that happened during the defense direct of this witness. They brought in binders and binders that had 500 pages apiece, so thousands of pages. But it didn't have anything to do with Wendy Adelson's case. It was to show another case that this expert worked on where it was contentious and fiercely litigated. And they wanted to show the jury the comparison because all of Wendy Adelson and Dan Markell's filings fit into one of those binders. That did get an objection from the prosecution, and the judge did clear the courtroom after that one. But Vinnie, I'm wondering if this means, because we're seeing a lot of intention from the defense on what happened after Charlie was convicted, when the flight to Vietnam and the informants and the jailhouse interactions that she had. And they're also focusing on the beginning, before the murder, the divorce, and the things of that nature. Are they going to embrace the middle in closings tomorrow, saying that the wiretaps, yes, the extortion theory from Charlie and all of that, yes, she wrote the checks, but she didn't know about it at the time of the murder?
That's a big mystery because she didn't testify, so it'll be up to the lawyers. Wow, what a day. You know, it's amazing how much happened even without Donna Adelson taking the witness stand. Julie, Janae, rest up. Closing arguments tomorrow. Wow, big day. Thanks so much. Let's bring back in our think tank. Still with us in the studio, Daryl Cohen, Meg Strickler, Josh Schiffer. Like, it wasn't contentious.
And why are you bringing
Wait. She was threatening to convert the kids and have them baptized. It wasn't emotional.
Are you kidding me? Especially the religious one? That one's huge.
Yeah.
The pretentiousness of the idea of their divorce wasn't that bad. Just how much hubris is involved in that position.
I think it's a bad look for that expert.
Terrible.
I think it's very
Why would you
interesting.
have an expert?
We were referring to the rule of sequestration. I think we ought to invoke the rule of frustration. And that, to me, is what this is all about and what precipitated all of the case that we're now seeing as a result of the murder of Dan Markell.
Donna wasn't getting what Donna wanted. To me, that's extremely clear. She's a meddling mother. She's a controlling person. We heard that from her son. We heard that from her children. You just know that. You know that. Now, obviously, we know the case better than this jury does because this is trial number, I don't know, 4 or so. So we get it. But at the end of the day, to try to paint a picture that this was not some sort of a bitter battle, to me is crazy, because it was about where these children were going to live.
And notice how well the state punctuated that this was performative, purposeful, intentional jury manipulation through a defense witness. The defense only called her for some very specific illustrative reasons. And what the state did in their cross was rip that Band-Aid off. Sure, but you're only here to try to show this divorce wasn't that bad. And look, we're gonna then have some additional theater with that binders later. I think that fell very flat. I thought it was a very difficult explanation, and it really didn't move the jury.
And my guess is that contentious divorce was probably people with lots and lots and lots and lots and lots of money who were fighting over lots and lots and lots and lots of money.
It obviously wasn't contentious. It only ended up in one murder.
Yeah.
Well, that's the thing. I mean, the prosecutor was able to bring out in cross was like, well, yeah, this could have gone on longer. Yes, the divorce itself, but there's always post-divorce stuff. Until those
didn't happen because he was shot and killed in his driveway.
That's what she said. That's what she was able to get.
Boom.
And she did that, mic drop, and walked away.
And combined with the analogy, we all, I think, universally loved that analogy.
Yeah.
And that's how you get a jury to understand.
That's why she's prosecutor of the year in Florida.
Yeah, that's how you get someone to really understand.
She might win back to back.
Great,
especially since Daryl's not practicing down there anymore. All right, stay where you are, folks. When we come back, another story everyone's talking about out of Kentucky. A cheerleader under arrest. Why? There was a dead baby in her closet.
Now, back to the Court TV podcast.
I understand you got terms as far as your pretrial relations. Make sure you're abiding by those terms. Stay in touch with Mr. Martin. We'll be back in court number 3 on September the 26th at 8:30.
Wait, please approach that one.
Sure.
All right, that is 21-year-old Lakin Snelling, cheerleader at the University of Kentucky. She's from Tennessee, but she was inside of a courtroom because she's been arrested after a dead baby was found in her closet. Let's get some more information tonight. Court TV field reporter Cody Thomas joining us tonight. All right, let's start from the beginning here. How did this investigation begin?
Vinnie, to understand all this, we have to start, of course, with what we know. And just a week ago, last Wednesday, police were dispatched to a home near the University of Kentucky's campus in response to an unresponsive infant. That's what the police document said. And of course, once they got to that home, that is when they found the young infant's body wrapped in a towel, dead on the scene inside of a black trash bag in Lakin Snelling's closet. Now, important to note, Vinnie, just today, just a couple of hours ago, the coroner put out a report that determined that the cause and death of this infant is actually undetermined, and that death investigation is still underway. Now, Snelling was, of course, taken into custody just a few days ago on Sunday, and police say that she admitted to giving birth, and she also admitted to concealing the birth by cleaning up any evidence in regard to the birth at all. And also, Vinnie, she was putting those cleaning items and chemicals also in the trash bag with the baby. Now, since then, she has posted a $100,000 bond and had her brief arraignment just yesterday, where she faces 3 charges. That includes tampering with physical evidence, abuse of a corpse, and concealing the birth of an infant. And of course, she's pled not guilty to those 3 charges. But that doesn't mean more charges aren't to come, because this investigation is still ongoing. And of course, she has a preliminary hearing scheduled for the end of this month on the 26th. Now, Vinnie, what's also very intriguing about this, now, she is a 21-year-old college student. Of course, she's on social media. Her most recent TikTok post, and we have a screenshot from that post. If you look towards the bottom left there, it's kind of small, but This post includes a collection of life goals outlined by emojis. Now, under that life goals, those emojis include the emoji of a mother holding a baby, the emoji showing and depicting a family, money, and a house. All of these emojis together implying that she wanted to be a mother and have a family of her own. Those were her life goals. So it's very intriguing considering the circumstances that she's in now. So, of course, Vinny, that's what we know. Now, what don't we know? We still don't know who made the 911 call, but we did confirm today here at Court TV that the Lexington Police Department will not release any 911 calls to do with this as the investigation is still ongoing. But what else don't we know? We don't know what sort of living situation was going on in that home. Did she have roommates? Was it a dorm? Was it a house? Was it an apartment? Was it some sort of property that her family owned? Who's the baby's father? These are all questions, Vinny, that we still need answers to, but I'm sure we'll get as this investigation continues. And of course, she's currently on house arrest and ordered with no ankle monitor, given the nature of the charges, but she's ordered to live with her parents, and the university hasn't released any explicit statements aside from the fact that she is a student and that she was a member of that cheer stunt team.
All right, Cody Thomas, thanks for all the info. Let's bring back in our think tank, Daryl Cohen, Meg Strickler, Josh Schiffer. This is a huge development, undetermined. How does that impact the potential homicide investigation here and trying to figure out what happened to this baby, when it happened, and who's responsible?
Cause of death is the determinative information. The state can't make a decision unless it's based on what the medical examiners come back with.
But we think now, since they're having to do more tests, get more information, do more things, they said undetermined at this moment. They're not done yet. So I think it leads towards more of an issue of when did this baby die?
And how did this baby die? And why did this baby die? Because she didn't want the baby.
Did anyone know that she was pregnant is the first question I have.
Yeah,
she did.
You've got that question, but what Daryl's really...
Did she? Did she know? I mean, there have been cases where women have not known.
I believe there was acknowledgement from other people at some point of the pregnancy, but really, follow what Daryl and Meg are talking about is there's a baby that's born. We all know a baby was born. How did that baby die? Did it die because it was abandoned and exposure?
Or did it die in utero? That's what I was...
Did it die in utero? But I'm getting to, or was there an action taken against the baby after birth?
After birth, right.
And that's why we're bruising some of the other issues that would take a minute. Babies, when born immediately, are the most fragile things in the world. Their skin is like paper.
We've covered stories like this, and it's incredibly difficult to prove how the child died.
Or when. That's the key part.
Let's wait and see what the autopsy results are. I suspect
it's undetermined.
Well, I think there's going to be more. I think they're doing more tests. It's too fast. They are doing more tests.
And the scrutiny on this, everybody's eyes are on this. That ME is getting pressured by everybody.
If it was like asphyxia or something like that, I think that would have been done immediately.
Well, are
they going to do a toxicology?
Sometimes a baby can die in you earlier on and then come out.
Yeah.
So if that was the case, that would have been more easily determined.
There could be a failure to thrive issue, which is surprisingly common with babies. There's lots of things. Or did she assault a baby, which is unfortunately in the realm of possibility.
That's why I think it's leaning towards that possibility versus what I was just referring to, because they didn't come up with an immediate answer.
Yeah.
I want my inquiring mind to steal it. Wants to know what the autopsy results are. Once we find those autopsy results, we will have an idea, a really good idea of how that baby perished.
They're also combing social media. They're combing all of the family, the relatives, the boyfriend.
Does a mother carrying a child like she was have an obligation to do anything and everything to make sure the baby is okay? Like, can you charge someone for the death of the child for not taking care of yourself, therefore not taking care of the child?
Was she having the doctor appointments? We know none of these things. So yes, you can be charged with those things.
What are you charged with?
There's deprivation. There's all kinds of requirements.
Is that going to be a homicide charge?
No. You could get pretty high up depending on how.
What I don't know in Kentucky is, can you be charged with the death of an unborn child?
Deprivation of a child leading to substantial injury and death.
In California, you can. What type of medical procedures she did or did not have. It depends on how many times, if any, she she saw the obstetrician. It depends, and that's the magic 2 words. It depends.
She could be charged for failure to take care of the child prior to its birth.
Well, let me ask you this. Does the fact that she puts the child in the closet...
With cleaning materials?
Right, but does that tell us anything about her mental state?
It tells me I'm scared, and I don't want anybody to know, and I'm going to try to hide this, and because I can close my eyes, no one else will know.
I mean, we could argue that the hormones were going crazy. We could argue she might have some mental illness. I don't know. I mean, these are the things that one could argue, and that she kind of disassociated from it and said, I don't think there's actually a baby, and that's why she was able to put this baby in a plastic bag. It blows my mind.
Which that's the part that anybody that's had a baby or been with someone who's had... You can't do anything. Like, the imagining harming something that precious,
I know.
It just doesn't even make sense.
No.
How the 911 call was made to me is also significant here. Why? Like, who called? What made them call? How was the child discovered?
Did they hear the baby cry?
Right.
You know?
Was there a discussion
We have
before?
so many questions and so few
That's
answers.
why we have Cody Thomas. We'll get some more answers. All right. Big thanks, Daryl Cohen, Meg Strickler, Josh Schiffer. Always great to have you. Don't go anywhere, folks. When we come back, I will reveal something else you need to know tonight. Tonight on Vinnie Politan Investigates, the dramatic case against Donna Adelson continues. Why didn't Donna testify? Tonight, we investigate.
This is the Court TV Podcast.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at the big board. And what do we've got? Oh, there he is, the Idaho mass murderer killer. New photos released. Wait till you see these. This is pretty interesting as we take a look at some photos associated with the Idaho killer. We begin with some birthday cards that he apparently received after committing this horrific act. His birthday, I guess, a week or two afterwards, 8 days afterwards, and there he is. Oh, look, your eyes. Yeah, he's got your eyes. They must be beady. Also, some notebooks were found as well. You can see some of the writings of the killer. All this stuff, part of the evidence in the case that is now being made public, finally. Let's take a look at his bedroom and how this guy was. Oh, there's a refrigerator. Not much going on there. I saw a little almond milk. This now is his bedroom. He's got a closet. Oh, a little bed. Not much going on here. Not much going on. Small apartment. Meager, plain, boring. Let's take a look at the kitchen. There you go. He's got lots of water. Electric stove, little cabinets, and he's got the microwave. That's probably how he cooked most of his food, my guess. And there's the refrigerator. You got some almond milk and some tofu. And I don't know what that is on the left there. I can't tell what that is. Oh, a little Italian food, some Thai food. I told you, microwave. King of the microwave. All right, enough of him. Take a look at your screens. You have a missing child who needs your help. This is Tanasia Hare. Tanasia missing from Gretna, Louisiana, 16 years old. Pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or you can call the Jefferson Parish Sheriff's Office down in Louisiana. Let's see if we can get Tanasia to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.
There you have it. If you want to see more in-depth reporting on the latest true crime stories, you can see me every weeknight, 8 p.m. Eastern on Closing Arguments. Thank you so much for downloading. And as always, please don't forget to hug the kids.
This podcast is a production of Court TV. Go to CourtTV.com for more content, trials on demand, and to find out how to watch Court TV in your area.